Kevin. Good afternoon, everybody, and thank you for joining another Out for Business webinar in our series that's now, I think, in its fourth month. We hope you're enjoying these get-togethers every other Tuesday. We certainly have had a good time bringing them to you. The one thing I do want to bring up today is, if you're not on our mailing list, please be on it and learn about all the things that we're doing, all the events that we're doing, and how we're trying to keep communicating with everybody during this COVID-19 pandemic. Particularly, go to our website. We have two calendars, and I want to make a point of this to everyone. We have two calendars on our website. One is called Events, and the other is called Community Calendar. And the events calendar are all the events that we pull together for our particular Chamber of Commerce. But the community calendar lists other important events that you'll probably be interested in. They have to do with networking events that are going on all over the country virtually, specifically with our sister chapters all around the country. They're really interesting, really fun, and you get to connect with other LGBT business owners and business people in different parts of our country. Additionally, too, we get notified a lot by the government, the state government, and by large corporations about online fairs and online opportunities to work with large Fortune 1000 companies and do business with the state government and county governments. All of those events are virtual right now, and as we get notified, we put them in our community calendar. They're all free, and you get a really good education from these organizations about how to get into the procurement stream, best practices, and really how you can start growing your business if you want to go the route of getting government contracts or doing business with Fortune 1000 companies. So again, go to our website, njlgbtchamber.org. Go to the calendars, look at both the events and the community calendar. There's a lot of good stuff there, and we update them every day, every week, if not every few days. Kevin, I'm going to pass it back to you to talk about our newest event that's coming up very shortly.
Thank you, Joe. Thank you again, everyone, for being here. I'm a fellow board member. I'm looking forward to hearing from Kelly as well today. Tomorrow we have a special event where we are going to be in Asbury Park for our first in-person networking event since this uncertain and new normal has started. So what we'll be doing is we will be at the Empress Hotel pool deck from between 6 and 9 p.m. tomorrow night, and portion of the proceeds, a majority of the proceeds actually, will be going to benefit Asbury Park Dinner Table, which is a nonprofit based out of Asbury Park helping people during this time. So I look forward to hopefully seeing as many people as possible tomorrow at a safe social distance event that we will make sure we take care of for you. Please remember to register in advance for both contact tracing opportunities as well as making sure we have adequate numbers of people that will be there. The Chamber is taking all precautions and all necessary responsibilities for this event. So we look forward to having a safe and fun and friendly networking event as we move into the new normal. So with that being said, thank you everyone for coming, and I'm going to move it over to Joe, who's going to introduce our fearless speaker today, the lovely Kelly Brown.
Thank you, Kevin. Okay, everyone. So our speaker today, our guest, is Kelly Brown, Counselor at Law. Kelly began her legal career 20 years ago as a commercial litigator, and then served as General Counsel for small businesses, and then within a business unit of a Fortune 500 company. Today, she's going to provide valuable insight on how to protect your business and personal assets, including incorporation issues, contracts, and safeguarding your intellectual property and proprietary information, including registering trademarks, copyrights, etc. Kelly is also a certified life coach, a theologian, and interfaith minister, and she brings a holistic approach to legal guidance and emphasizing legal counseling functions. She believes in connected and personalized service for each and every client. Her approach is first and foremost to educate, giving you the information you need to make the important and necessary decisions for your family and your business. Then she collaborates and designs a legal life for business plan that best suits your needs. And have your questions ready, because Kelly will be answering all the questions that we have going forward. And with that, Kelly, I'm going to turn it over to you.
Thank you very much, Kevin and Joe. I appreciate that introduction. As Joe mentioned, we're here to talk about how to protect your company. And the three topics I chose to speak about today are incorporation, contracts, and intellectual property. I have activated the group chat, so you can feel free to post the question. Alternatively, I'll be pausing at the end of each section and asking if there's any questions. And of course, at the end, I'll ask again. So don't be shy, feel free to ask any questions relevant to the topics. So the first thing we're going to talk about is incorporation. Why incorporate? Why incorporate? The main reason to incorporate is to protect your personal assets. Why is that? Because a corporation is a legal entity. A legal entity has the capacity to contract. It has the capacity to get credit and debt in its own name, which insulates your personal assets from the debt of your business. And in order to maintain that separation of assets of business and personal, you need to ensure that you abide by certain corporate formalities. And corporate formalities require a couple different things. It depends on the type of entity that you have, will determine what type of corporate formalities you must comply with. But in short, most people are S corps or LLCs, and I'll show you a chart in a minute about the different types of legal entities. And that just requires, depending on the entity, that you have annual minutes and that you keep track of certain resolutions. If you're going to take on debt, if you're going to lend money to your business from you personally or vice versa, you need to keep track of that. So the biggest thing to do, other than some annual minutes, is ensuring that your finances are separate. That means you have separate accounts, you have separate credit cards, and that you don't commingle. Why is that so important? Because if your corporate entity is going to maintain all the liability associated with your business, it needs to have sufficient capitalization to absorb any debt related to that. If it doesn't, it can then seep into your personal assets if you haven't maintained the separation. So what this is known as is the alter ego theory. If you're treating your business as an alter ego of you personally, the court is going to say this fiction of separating personal and business isn't going to be abide by. You are paying your personal business, your personal expenses through your business and vice versa. You're commingling funds, you're putting funds, personal funds into your business and vice versa, which means that if there is a problem with your business, your personal assets are now subject to getting seized in connection with any type of litigation or claim. So depending on the type of business you have and whether you have to worry about malpractice claims, whether you have a brick and mortar and it's slip and fall, whether you're a contractor and you have to worry about any type of general liability issues that could then spill over into any type of errors and omissions insurance, all of that needs to be thought about in terms of separating your professional expenses and your personal expenses. So the type of entities, you can see there's numerous ones here. Typically, small businesses fall into three. Either the first one, where they're a sole prop, or the last two, where they're an S corp or an LLC. A sole proprietorship means that you don't have a legal entity. So part of what we're encouraging you here today is to never participate in business activities under your personal name, because then you do not have the protection of that corporate entity. You don't have the legal protection that insulates your personal assets if you're out in the world doing business just as yourself. So you want to ensure that you have some type of corporate entity. The S corp and the LLC are typically the most widely used, and there's pros and cons to each of them. And getting into the deep nuances is outside the scope of this. But in just kind of to encapsulate quickly, an S corporation is similar to a C corp, which is pretty much the public corporations that you see on the Fortune 500 and being traded. Corporate formalities, not as bad as a C corp, but it's definitely much more onerous than an LLC. So an LLC can be a single member, multi-member organization that has members instead of owners, and then you have a managing member who's the primary person responsible for that LLC. When you have multiple members, you can rotate the managing member. There is significant tax advantage to an S corp, however, and that is if you pay yourself, if you're an LLC and you're a disregarded entity because you're a single owner or you're a partnership, multiple owners through an LLC, and you're paying yourself a salary, you're paying self-employment tax on all of that revenue that income to you. So the business is receiving revenue, but you as the owner are responsible for that revenue after your expenses on the personal income. So your income is going to be taxed at the minimum of the 15%. You're paying both the employee side and the employer side of taxes there. With the S Corp, what you can do is pay yourself a salary, a reasonable salary. The IRS says it must be a reasonable salary. And then you're paying the FICA, the self-employment tax on that salary, but then you can give yourself distributions as an owner, which is not subject to income tax. That is then a distribution and subject to capital gains tax, which is a much lower rate. So fortunately, LLCs can elect to be taxed as S Corps. That is basically the best of both worlds because you get the lower obligations in terms of the corporate documents and having to maintain the corporate structure, which is very not onerous for an LLC. So you get the benefit of that plus the benefit of the taxes for the S Corp. So you can only do that at certain times of the year. And typically it's ideally when you're forming an entity, you elect that right away. But if you could talk to your accountant, it's certainly something that should be considered. So next thing I want to talk about is contracts. The number one way to protect yourself outside of incorporating is ensuring that all of your business relationships have a contract. Why is that so important? So first, let's talk about vendors and customers, and then we're going to talk briefly about independent contractors and employees. So vendors and customers, you want to ensure that all of your pre-contract discussions are memorialized. You had conversations, you've agreed on what something's going to cost, you're probably agreed on the deliverable, you may have agreed on the timeline, but there's a lot of other issues attendant to your business relationship that you likely have not captured in a contract unless you have a legal background or you've had an attorney working for you regularly. So what type of provisions am I talking about? You can see here that I'm talking about expirations, breaches, terminations. When you go into a contractual relationship, you need to think about what it's going to look like when you're getting out of it, whether this is a partnership, whether this is a vendor, or with your customers or clients. You always need to think at some point, this agreement is going to end, and what is that going to look like? What confidential information have we exchanged? What information do we have about each other's business that we wouldn't want disclosed? Do we have confidentiality provisions in our agreements? If we're not worried about confidential information, is there breaches? If there's under what circumstances other than non-payment, which most people think of, but are there other breaches that we need to address? And if so, what does that default process look like? Is there a cure period? Does somebody have to tell someone, hey, I think you're in breach and you have 10, 15, 20 days to remedy. If not, I'm terminating this contract. Are no cure periods appropriate at all, given your particular business? So there's a lot of things you need to think about when you're going into a contract. There's also discretely legal provisions or limitation of liability provisions that circumscribe the scope of liability if there is a breach. You need to think about assignment, indemnifications, ownership of intellectual property we're going to talk about in a little bit. And you want to ensure that you avoid misunderstandings. I hear a lot from my business clients, well, I don't want to give a big contract that puts people off. Well, if you've ever been in a situation where a contract has gone bad, you probably would have been better off knowing that that person was going to be put off earlier than later, because that's a red flag to you. That's telling you that there's something in the negotiations or in the bargain for exchange that they're not comfortable with. And you want to know that up front. Contracts exist when there's a meeting of the minds between the two parties. If both parties are not agreeing on the salient terms of the agreement, one party can choose to try and rescind the agreement. So it's really important at the beginning of a relationship to think about what's going to happen when something goes wrong, what's going to happen when a contract terminates. And then independent contractors and employment agreements. This is a really hot topic the past 5 years or so. You've seen a lot of the litigation, the FedEx, UPS, a lot of companies have chosen to classify their employees as independent contractors. So an independent contractor is someone who's paying their own self-employment tax. The employer, the company, is not paying the self-employment taxes. They're also not paying benefits. They're likely not offering health insurance, 401ks, and a host of other federal benefits that come into play depending on the size of the company. So a lot of companies have chosen to shrink the cost that they have with their labor by classifying people as independent contractors. So the Department of Labor, we have this at both at the federal level and the state level, has gotten involved and said, wait a minute. If it walks like a duck, quacks like a duck, it's a duck. So you can't, company, FedEx, get to avoid paying payroll taxes and benefits to your drivers when you are, and there's tests that determine the extent of control that the employer has over the independent contractor. Are you providing them uniforms? Are you telling them where they have to be and when? Are you dictating the specifics of what they do on a daily basis? If you are, then you are an employer, and that's not an independent contractor. The typical independent contractor is a service person that you're going to hire. You're going to hire someone to paint your house. You're going to tell them, I want this color paint, and this is, when I want it done by. They're going to tell you the price. You're not necessarily going to tell them exactly what they're going to wear, if they're going to start at the top or the bottom, the method of doing it, or you might have a timeline when it needs to be done, but you might not be dictating, well, if you're not here by 8 a.m., the contract's in breach. As long as I get it done by the date, you're not really managing those things. So the government has gotten involved and said, a lot of these employees are being deemed independent contractors inappropriately. So there's this control test. The ownership of tools and materials. Who's providing the vehicle for the deliveries? Who's providing the tools to perform the service? Is the person providing their own tools, or is the employer? Is there a chance of profit or a risk of loss? The extent to which there is a risk of loss, in other words, if the company doesn't make money, the employee is not making money, then maybe they'll be deemed an independent contractor. The employee is getting paid hourly or salary, and they're not sharing necessarily in the risk of loss of the business, as well as the profits. I mean, there may be some profit sharing, but to the extent that there's any big liabilities, is any of that money going to be clawed back from that person? If not, they're probably not a independent contractor. And integration. How significant is the role of this position to the company's overall business? So those are just some highlights about contract issues, independent contractors, employees, customers. Is there any questions about any of that? Okay. I will take that as I did a very thorough job explaining that. So intellectual property protections. What is intellectual property and why is it important? An intellectual property is any product of someone's intellect that has commercial value. It's an intangible asset. The commercial value is measured by goodwill associated with the source of product or service. So I put a list here in this orange box of the main types of intellectual property. And I highlighted trademarks and copyrights because that's what I'm going to address. So we have trademarks, trade names, trade dress, copyrights, patents, trade secrets, and proprietary information. All of that is considered intangible assets that go toward the value of a particular brand or a particular company. You want to protect the value associated with the goodwill associated with your brand, and intellectual property is how you do it. So intellectual property allows the brand to stand out in the marketplace as unique. It identifies the source of the product or service, and this is becoming even more critical now on a global scale where there are no, geographic boundaries. In, ages past, intellectual property was a sign on the store on Main Street, and everybody knew the sign, but you didn't have to worry if that name was also being used, if that was in New Jersey and that name was also being used in California, most people really didn't care too much. It wasn't that much of an issue. Well, now everyone also has online stores, and there's a lot of shipping, and there's the lack of geographic boundaries has made intellectual property that much more significant tool in the arsenal of a brand and in a company. So let's talk a little bit about trademarks. So what is a trademark? A trademark is a word, design, or logo that's intended to communicate the source of a particular service or good. So it's an indicia of the origin of the service or good. The purpose, again, is to distinguish goods from those of others. So the standard for availability is not whether the exact name is being used with the exact spelling and the exact colors, but is it confusingly similar? That's what the US Patent and Trademark Office, that's the standard they use. Is it confusingly similar? So the way they distinguish that is through class of goods. So there's 45 different classes of goods with subcategories. And when you register a word, design, or a logo, and again, this is not a legal entity, the word, design, or logo is owned by the legal entity. So it's an asset of the company. So there's 45 different classes of goods that a particular mark would be registered for. A mark can be registered for one class of goods, or it can be registered for 10 classes of goods. When you file for trademark protection, you have to submit specimens that show that the good or product or service is being used in that class of goods. So whether it's website, if it's a product, you have to show pictures, you have to show specimens of the mark being used within that class of goods. So a sample of design would be the Nike swoosh. Everyone knows when they see the Nike swoosh what company that is. Even if it doesn't say the word Nike, the swoosh is indicia of origin for that product or good. So you can see, again, when I talk about confusingly similar, Lexus and Lexus, one's a car, one's a news service. And though they sound the same, they're not confusingly similar, not the difference between the U and the I in the spelling, but because they're in two different classes of goods. Patchmaster and Patchmaster. One Patchmaster is Scott's Brass, another Patchmaster is Drywall Repair. So again, these are the same names, but they can be registered and used in two different classes of goods. Would the consuming public be confusingly similar, be confused by the similarity of those marks? Because they're in such distinct classes of goods, the U.S. Patent and Trademark Office says no, there would be no confusion, so both of these marks can go ahead and be registered. And like I said, you can file for more than one class of goods. I get a lot of questions from my business clients about protecting an idea, about protecting words. You can't take out of the body of, from the public domain, specific words. You don't get protection of particular words. You only get protection within the context of those words describing a particular source of service or product. So there's different categories of trademarks. Generic, there's no protection available. So if you wanted to get protection for the word apple in order to describe apples, the U.S. Patent and Trademark Office would say, no, you do not have the right to take that out of the public domain because that is a generic word that's used to describe all of apples. Adhesive bandage is another example. There was litigation over Band-Aid. There was also litigation over Q-tips. When Band-Aids first came out, Johnson & Johnson was using the name. Other companies started creating Band-Aids and they sued them. Same thing with Q-tips. They started making Q-tips and they sued them. And they said, you don't have the right to use that name. Thus, adhesive bandage is now the generic name for a Band-Aid, and cotton swab is the generic name for Q-tip. So a company that has a trademark is obligated to enforce its rights. And in order to enforce its rights, it has to make sure other people don't use it so it doesn't become generic. On the bottom here, you'll see I have in Word this genericize. It occurs when a distinctive mark that was once identified to protect an individual user becomes generic. Zipper, nylon, linoleum, escalator, teleprompter, app, trampoline. All of these words were created by an innovator to describe a product or service that they created that became so generic they no longer have the right to that name solely for their particular product or service. So generic words cannot be protected. The next level is descriptive. Descriptive words have protection only if you can associate the mark with a specific source. So that word must have acquired distinctiveness, or what's known as secondary meaning, over time in order to get protection. So the example here is Vision Center for eye care. Vision Center could not get protection when it first opened for Vision Center because it is generic. But they used the name without protection for so long that it now has secondary meaning. That when someone says Vision Center, you have an image in your eye of what that is. Pardon the pun with the eye, but you have an image of the company that they're talking about. You know what the letters look like. You probably know what their colors are. So that mark has acquired secondary meaning. So both generic and descriptive, if you're a business owner, are not names that you want to try and get protection for. You either can't or you won't be able to for quite a while. What you want to get is ideally arbitrary and fanciful, or secondarily suggestive. So what's the difference between the two? Suggestive is you get protection because it conveys a concept about the product or service. So I have here Coppertone for suntan lotion, or Twitter for brevity and transient, similar to a bird song. Those names are protectable because they're suggestive. You know, there's a connection between the word and what the actual product or service is. So that can be protected. But the strongest type of protection are the arbitrary or fanciful words. What are these? These are words that are just made up. Prior to them existing, Exxon, Xerox, Kodak, Kleenex, these were not words in our lexicon. They were not words that were used in the public domain. These companies made them up. As a result, they have the most protection. So the more creative the name, the more protection a trademark has. Any questions about any of that? Okay.
Kelly, this is Joe Renga. I have a question for you, if you don't mind. When we're talking about trademarks and imagery that, as a business owner, I hope becomes iconic or something, you know, and people just remembered me by it, or if you've created a product that in and of itself will be the image. At what point should they come to a counsel like you to say, you know, should they come to you, well, once they've created this logo, let's say, if they've decided upon, or they've created this product, or should they have everything else lined up in their business of how they're going to market it, what they're going to do before they come to you to talk about the legal aspects and how they can best protect themselves from the get-go of when that product or service hits the marketplace?
Well, trademark rights are granted based on priority. So the first to register gets the protection. So the sooner, the better. You do have what's known as an intent to use. Now, you can only get protection by actually using the mark in commerce. So you can't say, oh, I just have an idea, and in, you know, a year or two, I'm going to have this product named this, so I want to go get protection. The trademark office is not going to give you protection for that. What they will give you, though, you can file an intent to use mark, which is typically if you're within 6 months, you can get that extended, I think, twice. So maybe up to 12 months, maybe 18, where you can file, say, I'm putting my flag in the sand, you know, on January 1st, 2020, that I want to be using this mark by January, 2021. So this way, when your trademark does officially register, you're going to get the date back to January 1st, 2020. So it's significant to do it as early as possible because you want to make sure that you get as much protection as possible, because the rights of trademark, even though, I mean, the law doesn't always evolve as quickly as technology in our world does. So trademark laws are often discussed in the context of geography, a senior or junior user in a particular marketplace. Again, like I said, it's a little different now with the internet, but you could have someone using a name, let's say in New Jersey, and it's a business throughout New Jersey, a bank throughout New Jersey, and they're using that name and they've never registered it. They have rights in that name. Now, somebody in California is using the same name independently and they choose to run to the trademark office. Well, they're going to go to the trademark office and register the name. The New Jersey guy is going to complain and say, wait a minute, I've been using that name. Trademark office is going to say, well, we're going to give it to the California people because they ran to the office first, but you New Jersey people have the right to use your bank only in New Jersey. Right? So California guy now has the rights everywhere else. He's got priority except for in New Jersey. So is that
yeah, yep.
Okay, great. So how much does it cost to get a trademark? So there's federal filing fees and there's state filing fees, but typically federal protection is enough. And they range from $250 to $400 per trademark per class of goods. And when I say per trademark, I want to be clear that I'm not just talking about the name of a company, right? You can also have the the strongest protection is a word mark, right? So the name, the brand, the DBA is, you want to get protection for that. But you likely also have the brand, maybe a tagline, colors, stylized font. So that would also be a different trademark. So you can get multiple trademarks for the same indicia of source. And you'll see that, Dunkin' Donuts, right? They have so many registered trademarks. America Runs on Dunkin', they have the pictures, they have the cup, right? So you can have a lot of different images that denote the product or service. So you can have multiple trademarks and you can have them in multiple classes of goods. So it's $250 to $400 depending. Typically these days we can keep it in the $250 range because you can do it all online, per mark, per class of goods. And like I mentioned, you can file an intent to use mark, though that will then have a separate filing fee. And then when you actually use the mark, you're going to update the fee, and then there'll be another fee. So it's more expensive, but it's generally the way people want to go if they know that their branding is really significant to what they're going to be selling in the marketplace. And the cost on attorney's fees vary. Typically, it's around $900 per trademark, and there may be additional costs for different classes of goods or for subsequent marks. What's really, really significant about wanting to protect trademarks is understanding the landscape and whether that mark is being used out there. And if it is it being used in your same class of goods? So typically people hire firms to do searches for that, and they could go as deep or as wide as you want, but you want to make sure you understand the landscape under which you're going to be putting this new product or service. And if there's going to be any competition, whether anyone's going to claim that you're infringing on their rights, and you may decide to move forward anyway because of like I said before, the geography of their mark is just in, one area, just in Denver, Colorado, whereas you plan on having a national brand, or you're just in, Monmouth County, New Jersey. So you don't think there's going to be a conflict. So you choose to register, or you choose to not register, and then they register. So there's a lot of things to think about, but I always recommend people to spend the money to get a search. A search varies depending on who you can get to do it, but typically you're probably in the $1,000 range, depending on how deep you want to do. And attorneys don't do that. There's third parties that do that. So I always recommend doing your due diligence for that. Any questions about any of that on the trademark side? Okay, then I'm going to shift to copyrights. So as I said, you cannot protect an idea. That comes up in trademarks, but that really comes up in copyright. So a copyright is the expression of an idea in a tangible medium. So a tangible medium means the expression. It's the content, it's the presentation, it's the organization. Words, musics, lyrics, software code, all of that is considered copyrightable, right? Again, the idea isn't, but how it's expressed is. So you automatically have rights, known as common law rights, in the use of a name, just like you did with trademark, right? You can use a name in a specific geography and get common law rights without registering. But by registering it, then you have national protection. So with copyrights, you also automatically, and you'll see on the bottom of my slides here, I have a copyright symbol, which means I'm putting everyone on notice that I'm claiming copyright protection in this presentation. Now, the concepts that I'm conveying are not unique. The ideas are not unique. I can't protect teaching you about or telling you about copyrights. What I can protect is the organization of my ideas and the colors and schemes and the presentation of it. So copyrights, you automatically have common law rights as soon as you put something down. By putting a copyright notice on it, you're telling people that you're putting them on notice that they don't have the right to use that. But you can take it another level and get a registered copyright. A registered copyright allows you to have statutory damages if somebody infringes and uses it, and it lasts for 99 years. So having a registered copyright is really helpful. But you really need to think about what you're actually registering, because the copyright only exists for that particular expression of an idea. So I had a client one time who did a copyright of their particular type of contract. They thought it was unique. A lot of time and energy went into developing it based on decades of experience. So they wanted that to be copyrighted. Well, then when they updated it next year, it's no longer the same version, right? So now you have to decide whether you're going to file an updated copyright to reflect that derivative use, or whether you're going to rely on the original copyright. And typically it depends on how significant the changes are. A couple sentences might not be a big deal. If you decide to reorganize it completely, put in a bunch of new thoughts, it may be worth it. So you'll hear about that from time to time, about derivative uses. That's a song. Someone then, takes the hook and they put it into another song. Litigation over that, right? Vanilla Ice was a big famous one with the Queen song. And oftentimes that's known as a license, right? So copyrights and trademarks are shared with third parties through licenses. So in my former life, one of the areas of specialty when I was in-house counsel was for franchise companies, which are very much a licensed model, right? You're licensing your trademarks to third parties, you're licensing copyrights to third parties. So I have here examples of business copyrights that people may want to think about: websites, training, curriculum, marketing materials, manuals, customers, vendor forms, contracts. All of that are things that are worth considering copywriting if it's significant to your business model. If you're just putting it together to make your life a little easier, but you don't really claim any proprietary information in it, then you don't need to be concerned about it. But if it's something that's critical, again, an intangible asset is commercial value to your brand. If something is critical to your brand, then it's considered something you should consider doing. Now, I really wanted to emphasize the significance of works made for hire. So if you hire a vendor, an independent contractor to create something, and I see this all the time with my business clients, they hire marketing people to create content for them. They hire IT guys to create software code for them. The law says that the owner of that copyright is the author and creator of that product. So even though you're paying someone to create it, and you may be giving them the ideas on how to create it, they technically own it, unless you have a specific provision in your contract with that vendor that says they are signing to you all copyright, all intellectual property. And there's numerous provisions. I have about 4 or 5, depending on the circumstance that I use, depending on what's being created. But you want to ensure that you are granted the rights to that. This is also the case with your employment contracts. Same thing. If your employees, you see this a lot in pharmaceutical industries, right? The scientists are creating various drugs. Technically, they would own the rights to that, even if they were being paid to create it, except for when they came on, they signed an agreement that says, anything I make is considered a work made for hire, and you, the institution, the Johnson & Johnson or the college who's in the research company, are getting the benefit of. I'm assigning all of my rights to you so that you can market it, and then they go on to name it. So it's really important that just because you pay for something, it doesn't mean you own it. And I've definitely had my numerous business clients come to me wanting to have a dispute over a vendor of theirs that created something for them, and then the vendor turned around and took an aspect of it and gave it to somebody else. And they didn't like that. Well, if they weren't protected by the provision, that person has every right to do it because they own it. So you want to make sure in the negotiations, going back to the very beginning when I was talking about contracts, that you're on the meeting of the minds. One of the things you have to ensure is that whoever you're hiring, if you're paying them for something, that they understand that you are going to own all the rights to it. And you want to have explicit provisions in your contracts that identify that. So any questions about that? That is the end of my spiel here. Any questions about the contracts or the employment agreements, intellectual property, incorporation issues? I know I just kind of dabbled in them, just kind of wanted to identify some highlighted issues for people. I tell my business clients, you know, it's important for you to understand and be educated about these issues so that you can raise your hand and know when you need to reach out to an attorney. It's known as issue spotting, as they teach us in law school, right? You need to know enough to be able to say, I think I might have an issue here, and it's worth going one step further to contact somebody. So I'm hoping that I was able to give you enough information so that you can issue spot.
This is Joe, Kelly. I think you have, and that's what sparked my question about when should someone go to you? You know, when they're neck deep into their idea, their concept, their business, they're ready to go, or should they, when they're thinking about really pulling something together, should they take a time to come to you and say, Kelly, what should I think about? I'm about to really pull everything together, or bring everything to you once they have exactly their concepts and everything and their operations down, how they're going to do it? When's the best time to pick your brain about this and say, you know, what paperwork do we file? What do we do?
Right. I think earlier the better. So
Yep.
I personally offer what's known as a lift business session, which is legal, insurance, financial, and tax issues. It's ensuring that businesses have a solid foundation. The earlier in the process that I can talk to my clients, the easier it is to establish those foundations. The easier it is to ensure that there isn't any lingering risk out there that we need to try and mitigate, right? So when I have plenty of clients who are coming to me, they've been in business 5 years, 10 years, 20 years, and we're having to clean up stuff. And we can certainly do that. I do that a lot. But the earlier that you can consult with an attorney, again, the easier it is for you to kind of clean up things and make a priority list. You're not going to do everything, initially. You want to market, you want to sell your product, you want to have a demand, you want revenue. So there's a lot of things you need to focus on as you're starting a business, or as you're an existing business, but you're adding a new product line or adding a new service, or you're getting ready to grow. But there's definitely legal fundamentals that are easier to implement the easier and cheaper, the earlier that an attorney is consulted.
And I have a quick question too about copywriting. Sort of a point of clarification, as I've kind of loosely understood it. You can copyright, say, a work. If you wrote a book, you can copyright the book, but you can't copyright a title. Like, I could write a book right now. From my understanding, titles can't be copyrighted because, as someone once told me, they're so limited that to always come up, everyone who ever wrote anything, to come up with a new title would be impossible. So titles are not copyrightable, just the work itself. Like, I could write a book about the Chamber of Commerce and I could call it Gone with the Wind if I wanted to, and that would be okay?
Yeah, I don't know that I necessarily agree with that.
Okay.
I understand where they're coming from, but again, from my perspective, the idea, and I think that's what they mean, the title, and they're probably shorthanding it for you. To the extent to which the idea of the book is expressed in the title, that can't be protected. The idea isn't protected. But the expression of that idea in a title, I think, could be. So, for example, Gone with the Wind obviously is a movie, but if you had a fan that you were calling Gone with the Wind, could that be protected if you were writing a book about that? I think probably it could. So, as with most things in the law, the famous line is, when someone asks you if something's legal, you say it depends. I would not do a blanket characterization that all titles aren't protected, but I will say there's a heightened standard to the extent to which that idea is being expressed in that title.
Okay. Thank you.
Sure. Any other questions or thoughts? Nope. All right. It's a quiet crew.
Yes. But Kelly, we thank you for being here, and thank you for giving us all this information. It's something I think that many of our members should think about, because we do have a lot of members who are not business owners, but are on the cusp of being it. So I think this type of subject matter is really important. We all appreciate the fact that you did this for us today, and we hope you come back one day.
Yeah, thank you. I appreciate it. Happy
Thank
to
you
help.
so much, Kelly. We really appreciate it.
All right. Take care.
Take care, everyone.
Bye-bye.